Ms. Bailey Quick clearly understood that she had a choice, and she made her choice. An attorney simply skipping out on a show cause puts you, Mr. Dundon, in a worse position. And I'm going to be as explicitly clear as I can. If she's not here, I will take the unusual and extreme remedy of issuing a bench warrant for her arrest. But enough is enough.
We see judges get on defendants' cases all the time about not doing what they're ordered, but we rarely get to see lawyers threatened with arrest and contempt. So when we do, it's something. This appears to be a civil suit of some sort, and the parties all showed up except for the one attorney. She's busy doing other things, so she sent this poor schmuck to stand in for her and received Judge Hunter's chewing out. Following that, we have a judge in Cass County, Michigan, who threatens to haul a probationer straight to jail after hearing a weak excuse as to why he ghosted the court. Last, we have a probationer who failed to report for a jail sentence, but did report to Judge McScreamy's court with his lawyer. There wasn't much she could do. Let's roll hers.
And the court is on the record and calls the matter of Megan Lilly versus Christina Lilly. This is file 25-11910-DO.
Good afternoon, Your Honor. Adam Byrne on behalf of Nathan Lilly.
Good afternoon, Your Honor. Mark Dundon standing in for the attorney of record, Miranda Bailey Quick.
Mr. Dundon, you're in an unfortunate position, and I apologize to you for that, but it's not of your doing, and it's not of my doing. We're not here just for a hearing on a motion to compel. That's one of the things we're here for. And we're not also here for a status conference, although that's one of the things we're here for. We're here because Ms. Bailey Quick failed to appear in court, and I issued a show cause. And the typical way that I handle show causes is I have a direct conversation with the attorneys. And I can't recall a time that I've had to have anything other than a single conversation, and that the attorney isn't apologetic because they double booked or had something going on and they forgot or there was an error, and I've set it aside. But I set show causes to have those discussions. You are here attempting to appear on behalf of Ms. Bailey Quick. Were you aware that there was those triumvirate of things, a motion to compel, a status conference, and in order to show cause?
Yes, Your Honor. I was aware. Ms. Bailey Quick has been off on a medical, but then she was still clearing some stuff up. Again, I can try to text her right now. She's definitely not. There's an evidentiary hearing that she can't not be at today right now, but I know she's not obviously blowing the court off, for lack of a better term. But I do understand this is a delicate situation. What she explained to me is that when she was leaving Harris, the Harris firm, there was an issue with the two.
Mr. Dunn, respectfully, I'm not going to hear your reasoning for why Ms. Bailey Quick wasn't present, or allow the record to stand unchallenged that Ms. Bailey Quick isn't blowing this court off because she apparently has a different court to be in. Because the facts, as they say, are what they are. I had a show cause set. Another court in another county might have an evidentiary hearing set. Ms. Bailey Quick clearly understood that she had a choice. One of her choices was she could appear in an evidentiary hearing. One of her choices was she could appear at this show cause hearing. And she made her choice. So I understand why you, as an officer of the court and as a colleague of Ms. Bailey Quick's, would attempt to come to her defense. But those are the bare facts. I'm not going to permit that type of action to take place. If I did, I would have those issues in the future. So I'm going to do two things today, perhaps more. First, on the motion to compel answers, I would note that I've had a chance to review the motion to compel answers. I have not received any response. The court has the ability under the court rules to require a written response to any motion. I have no written response, and my requirement, and Ms. Bailey Quick is well aware of this, is that she must file a written response if she wants me to consider any written answer. She's not done so. The court's not considering any written answer, even if it was supplied, because it wasn't supplied to me. And so the motion to compel is granted its entirety. I'm ordering that the full answers must be delivered to the Office of Terry Jaskowski within 14 days of today's date. And I'm signing that on today's date, 12/1/2025. Mr. Deming, if you didn't know, Mr. Burning prepared a proposed order. I'm signing that order. And again, I'm just indicating that the order, that the answers must be supplied within 14 days of today's date. I'm handing this to the clerk now for filing. In terms of the it's not, I'll let you ask any questions in a moment, Mr. Deming, but I'm
yes, sir.
methodically through these things before I do. In terms of the status conference, I'm not going to do anything because there's nothing I can do. I don't have the two parties, the two attorneys here. Mr. Vernon and his client are here. They're ready to proceed. Ms. Bailey Quick, again, is not. And I'm not yet foreclosing a chance that I would perhaps make a finding of good cause later. But I'm also indicating that I don't intend to allow to pass an attorney simply skipping out on a show cause. That sets a terrible standard for the bar. It puts the court in a terrible position. It probably puts you, Mr. Dundon, in a worse position. And I don't intend that feeling for me, for you, for Mr. Lilly, or for Mr. Vernon to have no consequence at all, even though that's exactly what I intended if Ms. Bailey Quick would have done what I told her and required her to do, which is appear today for a show cause hearing. So while I have not decided ultimately what I'm going to do on the show cause, I'm going to adjourn both the status conference and the show cause. I'm going to order that Ms. Bailey Quick appears in person for the show cause at my next available date. And I'm going to be as explicitly clear as I can. If she's not here on time and in person at the next time I set an order to show cause, I will take the unusual and extreme remedy of issuing a bench warrant for her arrest. Believe me when I say, counsel, Mr. Lilly, that's not something I'm considering lightly, and it's not something I'll do lightly. But enough is enough. Ms. Bailey Quick needs to appear at her hearings, especially when it's a show cause. Mr. Vernon, did you wish to make any record regarding either the motion to compel, the court's treatment of the show cause, or the court's treatment of the status conference?
I would, Your Honor, with regards to the motion to compel, I would ask the court to consider, consistent with our motion, some costs. This is now, this is the third hearing we will have had on the status conference and this motion to compel. We had to draft a motion to compel. We had to appear at this hearing, and I'll have to draft an order to that effect. And now we have to appear at another hearing on the status conference. So I probably will have had to have attended 2 additional status conferences in addition to the work I did on the motion to compel. In addition to my preparing the order to compel, we would ask the court to consider, I told Mr. Dunn that I was looking for 1.5 hours of work up to today, with the idea that we're going to have another status conference and prepare the order. I would ask the court to consider 1.75 hours of costs that my client has to incur as a result of Ms. Bailey Quick's failure to comply or failure to provide discovery consistent with the court rules.
Mr. Dundon, did you wish to respond to that request?
Your Honor, I kind of don't feel like I'm that well equipped. Usually downstate, I guess what I would have seen would be a email or something to an attorney saying I need this discovery. I'm not sure if that happened, but nonetheless, Mr. Vernon is entitled to his discovery, and I believe the court rules speak for themselves as far as what the remedies are, Your Honor.
Mr. Vernon, I'm inclined to grant some costs because I think it's fair for you to claim error by Ms. Bailey Quick in not responding to the motion, not supplying the information, and then not being here today. By my count, we've been on the record about 10 minutes today. Your estimated time for your motion, notwithstanding, I would note that your motion, while it was detailed enough for me to grant you relief, it's also page long. It didn't take you, in my view, very long to put it together. It won't take you very long to put together any order because you already did. I've got it and I've signed it. I'm going to sign it and order these costs. My view is that in totality, between the frustration that you and your client have suffered from Ms. Bailey Quick not being here today, for not being here and needing to reset the motion hearing or the status conference hearing and the order to show cause, it's my view that an hour is a fair amount of compensation. What is your hourly rate in a hourly matter?
$325, Your Honor.
325?
Yes, Your Honor.
All right. The court is going to award that time $325. I'm going to order it payable to Carrie and Jaskowski PLC and no later than within 14 days, the same as the order with regard to the production of documents. And I'm going to order further again that I'm going to set this for a follow-up status conference in order to show cause with Ms. Bailey Quick in person. Mr. Vernon, because I know you're local to Grayland, you're welcome to be in person as well. I don't require that, but if you wanted to be in person, sometimes that's a better way for all of us to proceed, but I'll leave that to you. did you have any further questions, Mr. Dundon, or for anything further you want to state for the record since we're all here?
No, thank you, Judge. I just want to, so the court's you're scheduling the next day, Judge, but it's you're not exactly sure when.
Correct. I'm going to set it. I'm going to have the staff set it. Ms. Bailey Quick will get a notice and she's required to be there in person.
Yes, sir.
And hopefully you can communicate to Ms. Bailey Quick the tone and tenor of this hearing as well, because this is not something that I think any one of us should have to deal with. And I hope Ms. Bailey Quick is aware of that.
I will definitely, Judge.
Mr. Vernon, anything else?
The court wants 2 separate orders, one order on the costs and one order on the motion to compel, or is it all in one order? Okay.
I just hand wrote in from the order that you prepared. I have it all in the same order.
Oh, okay.
Yeah, so the court already has the order.
Okay.
And I would note that your proposed order, I'm glad the clerk just saw that. It said Christina Lilly shall pay the assessed costs. That's wrong. Miranda, counsel for Christina Lilly. So counsel, I'm writing in counsel for defendant shall pay the assessed cost of $325. Again, my view is that the problem that amounted to the need for sanctions, in my estimation, was not so much Ms. Lilly not providing answers as Ms. Bailey Quick not being here today in order for the court to get out of business and otherwise have a contested hearing.
Thank you for the clarification, Judge. I have no other questions.
Thank you, counsel.
Thank you, Your Honor.
Move on record file 22-10346 State of Michigan. Dennis T. Dial was present here in court, represented by his attorney. School, and you were back in court on the 17th of November. We rescheduled it, and appointed counsel. So, sure you know, if you get a chance to discuss the request for workflow information violation.
I did, Your Honor, and there appears to be a pending file out of St. Joseph, Indiana. There is going to be a pending case due to those allegations. So at this time, Your Honor, due to the pending file that's down there, I would request the court adjourn that. I would also like to address some of the bond conditions they currently has, but in lieu of, he's currently ordered to stay in Michigan. He is staying in Michigan over in Edwardsburg. He does have a place to stay, but he does do some work that requires him to travel between Michigan and Indiana. And of course, he does also have a pending Indiana case as well. So I just wanted to address those items as well.
Okay. David Barnwell, I see you there. Is this your case now, or are you handling it for Agent Browning?
I'm handling it for Agent Browning. And is this Dennis Charles?
Yes. Yes. File 22-10346 FA, signature was Dennis, Tyler Giles.
Yes, sir.
Mr. Giles is present here. It is. We were showing, at least at the time, the case at one point was transferred to Indiana. And we had to live at 58976 Comstock Highway in South Bend. Is the case still open in Indiana? Because when I looked at the family report, I didn't know if they discharged him or closed his case down there, at least for supervision. Do you have any information in that regard? I believe that was the issue that we had. And that's what happens when your case is transferred to another state and you don't report, they close their case out, and that means you have to come back here. And so that's what happens when you get yourself in those kind of situations. I don't know if we can even address any of those yet, because I don't know if Indiana would even accept him back. So I think that's what was that original issue when we had him in.
I don't believe the case is open for Indiana. We'd have to resubmit that. Agent Browning has left numerous voicemails requesting that he return a phone call. He has not done that. I believe last week that a warrant was issued for Mr. Giles for absconding.
Down in Indiana or here?
Here in Michigan, Agent Browning submitted that.
So, Mr. Giles, let me ask you, you have charges pending, or are there going to be charges in Indiana?
Yeah, I
Do
do.
you have an attorney?
Yes, I do.
Okay, and who is that attorney and when do you next appear in court?
January 3rd, I think it's my full court.
You know who the attorney is?
His name's Susan. I can't remember her name exactly.
You might want to remember the names of your attorneys because you're digging yourself quite a hole. You failed to report, you failed to appear, your case was closed in the end. Do I need to have you take you out here, put you in jail so that when they say you call and talk to somebody that you do it? Do we need to do that?
No, Your Honor. I haven't had it at home. I just got my phone with it.
Okay, well, just because you're on the phone doesn't mean you ignore a probation agent or you ignore the court. You don't, it's not an excuse to come in and go, oh, I didn't have a phone. Because you know what, if that was the case, that's what everybody will say.
Yes, Your Honor.
You're on probation. You have an obligation to stay in contact with me. And you have to do it. Do you think this was a joke?
No, Your Honor.
Okay, because if you want, I'll take you right back there. I got a gentleman right there, take you back, and then we'll know where you're at. Is that what we need to do?
No, Your Honor.
Then you need to contact a probation agent. Does he need to come over to the office today, Ms. Cornwell, or what does he need to do? Needs to come over today?
That would be perfect.
Okay.
Yeah.
You will go to the probation department following court today. You will report. If you fail to do that, you will sit in jail until these pleadings are completed. You understand that?
Yes, Your Honor.
Okay. It's in a joke. Committed an offense. You need to be grown up about it, and you need to listen to follow the directives of the court and your probation agent. If you don't want to do that, we can make you. If you want to push this to that point. You understand?
Yes, Your Honor.
One of the reasons I'm going to continue on probation, the problem that you've got yourself into is you're going to stay here in Michigan because, like I said, you didn't report, they closed your case. Now the only way to do that is for them to try to get them to reopen it. So I would tell you, you're going to want to cooperate with them and listen to everything they tell you very closely. Because if you want to get this case transferred back down there, you do it. It's not just get back down there and then ignore them again. If you want this case handled down there because you want to live down there, was it your father's house that you were staying at?
Father-in-law.
Your father-in-law, so I know there was a reason you wanted to be there. If you want to do those things, it takes cooperation. We more accommodated you, we let you transfer your case down there. We're trying to work with you, you still want to work with us. So it's time you start working with us. And when you leave court here today, you report to the probation department, and if you fail to do that, unless you've been for it, and you will not get out of jail until these proceedings are done. You understand?
Yes, Your Honor.
Now make sure, I want you to also get the name of your attorney to Attorney Ho, so that he can be in contact with the attorney on there so he knows what's going on. Okay? You tell me, I think it's January 3rd. You ought to, those dates ought to be ingrained in your brain, or at least that you get them with Attorney Ho, so that when we come back to court here, we know what the status of your file is, okay?
Yes, Your Honor.
All right. Attorney Ho, you have anything further?
Yes, sir. I understand that we can't transfer his file back down there because, of course, we have this pending issue up here. But due to the fact that he does have a case in Indiana and he does have employment in Indiana, I would at least ask that his bond conditions would allow him to at least leave the state of Michigan for those limited purposes.
I don't necessarily have any objection to that. If you can leave Indiana for work purposes, whatever purposes.
To attend his court hearings.
Yeah, well, or, yeah, I mean, but you need to make sure the probation department knows that, knows where you're working, when you're working, knows when your court dates are. I don't have any objection. We try to accommodate. You've got to work with us. If you don't want to accommodate me, I can't accommodate you. So if that's what you want, then you need to make sure that you're in contact with probation and that you make sure they have the information. So, anything further, Ms. Cornwell?
Yes, where is he going to be residing in Michigan? And he would also need to have a travel pass each time
Yeah,
he would go down
we're
there.
gonna have him report, and if you can just address that with him when he gets there, hopefully he can give you that information. I mean,
Okay.
and then, again, and those are, you just kind of position you got here, and yet you kind of get travel fast and something like that, till we get stuff in the list. Anything, do you have any other questions, sir?
I got it.
Okay. We'll go ahead and adjourn then and report to probation, okay?
Yes, sir. Thank you.
All right.
We'll get going, right?
Court is on the record in State of Ohio versus Ezekiel Howard Lucas, case number 25 TRC 724. In this case, Mr. Lucas was convicted of operating a vehicle under the influence and driving under OVI suspension on September 10th, 2025. As part of his sentence, he was placed on supervised community control with this court for 30 months with several conditions. Mr. Lucas appeared on November 17th, 2025 for a preliminary revocation hearing based on a probation violation complaint filed against him on October 29th, 2025. At that November 17th hearing, he was present without counsel and entered no plea to the probation violation complaint. Bond was set, and this case is set today for a final revocation hearing. Mr. Lucas is present. He's accompanied by his attorney Edith Jonas. Also present are Law Director John Lewis and Probation Officer Sean Benoit. Mr. Lewis, can you advise us of the status?
Yes, Your Honor. Thank you. The offer that's been discussed with Ms. Jonas regarding this final revocation hearing would be, the offer would be for Mr. Lucas to admit the violation with the state of Ohio then recommending that his supervision be extended for a 3-month period. This has just been brought to my attention this morning that Mr. Lucas had a jail report date of this morning at 9 a.m. And obviously he did not report for that. And I discussed the matter with Ms. Jonas. She's indicated there was some confusion between herself and her office rather and Mr. Lucas. So I'll let her delve into that, Your Honor, more deeply. But recommendation is to admit and extend his supervision for 3 months. Thank you.
Thank you. Ms. Jones?
Yes, sir. We would be admitting to the violation and stipulating to the 3-month extension. My client, after talking with him briefly, sir, so the drug and alcohol piece might not have been the right path, understanding that it was an OVI, but it seems to be more mental health. And I believe Lark can confirm that he is in their I call it a PHP program, but I don't think it's a PHP program.
It's mental health day treatment.
Okay, and it's 2 days a week, and he has been attending that. He's been negative, sir, in all drug screens, drug and alcohol screens since you ordered him not to, and he will probably tell you that he has not been drinking for 3 months. As far as the jail report date, sir, he called. We didn't get a copy of that judgment entry, so when he called our office this morning, he asked if he should jail report at 9 or the 11, and they said they didn't know anything about the jail report, that he had to show up at 11. So he did not show at 9, and I'm thinking it's because our office directed him and was not aware of the jail report date.
Okay. And did he do the driver intervention program?
Thank you, Your Honor.
Okay.
Can I speak?
Just on the driver intervention program,
Right.
did you do it?
No, but I did sign up and I'm paying for it for Lark. I'm going to Lark.
Do you know when we're taking you?
They're all booked up. They're booked up until next year sometime.
Have you signed up?
Yeah.
Or they know you have to go?
I just gotta pay it before then. They're like, something.
Okay, well, we'll address that here shortly. Mr. Lucas, it's my understanding today that you wish to admit or plead guilty to the probation violation complaint filed against you in this case on October 29th, which alleged that you failed to comply with your treatment recommendations of the Lake Area Recovery Center by denying intensive outpatient services on that date of October 29th. It's my understanding you're going to plead guilty to that complaint. Is that what you wish to do today?
Correct.
Do you understand by pleading guilty or admitting to this complaint that you are waiving your right to a final revocation hearing, which means you'd be waiving your right to cross-examine witnesses and to confront evidence presented against you? You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to be proven guilty by a preponderance of the evidence. All of those are hearing rights you'd be waiving by pleading guilty to this complaint today. Is that what you wish to do?
Correct.
You are represented by Ms. Jonas. Have you had sufficient time to consult with her, and are you satisfied with her counsel?
Correct.
Has anyone made any promises to you about what your sentence will be in order to induce you to plead guilty or admit to this complaint today?
No promises.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking today?
No.
Are you currently on probation, parole, community control, or post-release control with any other court?
Probation.
Where?
Asheville County.
The county level, common police court?
What's,
Eastern County Court?
We would be Asheville,
yeah, municipal,
Asheville.
So you're on probation with two courts?
I believe, yes.
Okay, are they aware of this violation complaint?
I don't think so, maybe.
Are you facing a probation violation in that court?
I'm not court ordered to, like, see my parole officer, so
It must be unsupervised. I'm checking it.
it's unsupervised, yeah.
Okay. Are you thinking clearly today, Mr. Lucas, and do you understand everything that's happening?
I do understand.
Okay, Mr. Lucas, I'm going to provide to you and Ms. Jonas a written waiver of hearing rights on probation violation matters. If you find that document acceptable, you can sign and date at the bottom. The court does find that Mr. Lucas and Ms. Jones have executed the written waiver in open court. The court does find Mr. Lucas's plead guilty or admission to the probation violation complaint filed against him on October 29th, 2025 to be knowing, voluntary, and intelligent. Court will accept the admission or guilty plea, and I will therefore find him guilty of violating his probation in this case. Okay, Ms. Jonas, is there anything further you would like to say in mitigation of sentence?
Just for the court's record, I'm not finding him in Asheville Municipal Court unless they spelled it differently. So I'm not sure he is on probation board, but in either case, sir. I note that I probably would have filed a competency on this one, sir. I'm not sure. Mr. Lucas works full-time. He does second shift at one of the local factories. He, I think, is trying to comply to the best of his ability. I think there's a lot of things being thrown at him, and I'm not sure that he's understanding all of it. So I think the mental health path that he is currently on through LARC might be a better path for him than trying to do all of it. He has been negative since this court ordered him to be negative. He has not had any positive tests of anything. And again, I think he's trying to comply the best that he can with a lot of stuff being thrown at him, but I'm not really sure he understands all of it.
Okay. Thank you. Mr. Lucas, is there anything you would like to say before I impose sentence?
No, sir.
Mr. Lewis?
I have to leave that, Your Honor.
Officer Benoit?
Yeah, nothing to add, Your Honor. Thank you.
Mr. Lewis, I do see that you subpoenaed today someone from Lark.
Yeah, she's here with me.
Okay.
Jasmine Malik.
Okay. Ms. Jonas, do you have any objection of me inquiring of Ms. Malik?
Yes, sir.
Ms. Malik, you were subpoenaed today. Are you dealing with Mr. Lucas in his treatment there?
So I'm his case manager.
Okay.
I don't work with him directly.
Okay.
I kind of just oversee his chart and have a working knowledge of, what group he's in, how his screens look, if he's reporting, if he's seeing his individual counselor. I kind of send those monthly to Mr. Benoit. So I have an idea, but on a one-on-one basis, I don't work with him in that way.
Okay. Thank you. I do have a letter in the court file dated October 31st from Lark. That would have been 2 days after his, when he apparently denied IOP. Apparently he arrived at their office on October 31st. So, Officer Benoit, is this something that Mr. Lucas did in response to the probation violation complaint?
Yes, Your Honor, he did go in. I got on October 29th, 2025, at 1 o'clock, he reported Lake Erie Recovery Center for an updated assessment. And then he began complying with their recommended treatment plan.
October 29th, that would have been the date of the violation.
That's when, according to this, that's when he missed good. He completed his updated assessment.
So what was the basis for the violation then on
He
October
was
29th?
recommended to attend
Inpatient.
intensive outpatient services on October 29th, and he denied those services, and then he reported back in to do his assessment.
On October 31st,
Yes,
which is what I have in the report. So I can see he's attending mental health day treatment. That's a group, Tuesdays and Thursdays from 9 a.m. to 12 p.m. He has individual therapy that started on November 14th. In addition to the screens. Yeah, Ms. Jonas, I've noted this isn't new. I mean, Mr. Lucas exhibited this type of behavior to the court ever since his initial appearance hearing in August. He's, and I did order as part of his sentence that he continue, because at the time of the sentence, it was my understanding he was in treatment at Lark for mental health and substance abuse purposes. I will go ahead and extend his probation for 3 additional months in this case and order that he successfully comply with, it's really just a confirmation of what I've already ordered, that he continued successfully to receive any and all mental health and substance abuse treatment from the Lake Erie Recovery Center. I will suspend the amount of jail sentence of 170. Actually, we have to address the jail report issue. He was given 6 actual days, 3 days on each of these sub cases as they were run consecutive to each other. I did allow the driver intervention program to be in lieu of the OVI case, that being the subcase A charge. So, Mr. Lucas, I'm going to ask you this pointed question. When was the first time you made arrangements for the driver intervention program?
It was, I want to say like a month after I started LARC. Maybe.
Because you were sentenced here on September 10th of 2025.
So the next month around there.
So did you provide any information to the probation officer about that? I mean, you know.
I think, what was her name? Who was the ME count?
Aaron.
What was it?
Aaron.
Yeah, Aaron. I think Aaron did let him know about me like making the appointment for it, but I don't know if he got the message or.
Well, you know, did you ever think of asking him or talking to him about that issue? I mean, we gave you a 6-day jail sentence. You were to start at 9 a.m. this morning for 6 days. I would have taken 3 days off of that jail sentence if you completed a driver intervention program. Did you want to serve all 6 days?
No, but at the time, all I knew was LARC. I was going through LARC for this, so I figured I could just do my driver intervention at LARC, and LARC is just backed up at the moment.
So you are not currently scheduled for a driver intervention program?
I am.
When?
I don't know the exact date, but it's after 2025. It's next year. Because that's how far they're backed up.
I understand, but did you give anyone notice that you have made arrangements with the LARC for the driver intervention program?
I believe Aaron did.
Okay, do you have any record of it?
No, the only note I have is from October 7th, 2025, where Mr. Lucas stated he was going to complete his 6 days instead of completing the driver's intervention program. It's the only note I have in my system.
Ms. Mulliken, do you have any record of it?
Yeah. I do know that they only run 8 a year though. So there isn't any in December. The next one would be January.
Yeah, that's.
You were sentenced on September 10th. Should have made arrangements the next day. Okay?
Okay.
That's what I'm getting at. He still has to serve 3 days. Take him downstairs. He's going to serve 3 days on the jail jail sentence. Now you're going to go to jail, and you're going to spend 3 days. I'm going to give you until January 30th to complete the driver intervention program on the other 3 days. So we're going to take you in the jury room. You're going to wait there. We're going to call the jail to make sure that they will take you for 3 days. And then if they will, then we'll take you downstairs. If for some reason they can't take you today, then we're going to come back in the courtroom. Okay? Okay. You do have a right to appeal. You have a right to appeal without cost. You have a right to have counsel appointed on appeal without cost. You have a right to have documents provided to you necessary to file an appeal without cost. And you have a right to have a notice of appeal timely filed on your behalf. Anything further, Mr. Lewis?
Also,
Ms. Jonas? Officer Benoit?
No, Your Honor. Thank you.
Thank you.